Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. And in today's presentation, legally speaking presentation, I would like to give you updates on recent immigration news. And we have a lot of updates. Over the weekend, basically on Friday, we received a lot of news, affecting various areas of immigration law, particularly public charge, TPS, temporary protected status. Today we received some updates regarding deadlines. So thank you for joining me, and we're going to basically start. I'm going to provide you with some most recent updates. Well, first of all, public charge is back nationwide. Hi, Karine. Hi, John. Hi, guys. Thank you for joining. So, public charge is back nationwide. Public charge roller coaster keeps rolling. We had the Second Circuit ruling first that there was a nationwide injunction against public charge. Then it was changed to injunction only for New York, Connecticut, and Vermont. And now public charge is back for everyone, including New York, Connecticut, and Vermont, Second Circuit, okay? To my knowledge, still on USCIS website, there is no update related to Form I-944, but I can assure you that most likely soon something will be published. So for those of you who are in the process of assembling your documents for adjustment of status, be aware that you either will have to be submitting Form I-944 together with your adjustment of status package very shortly, or you will be requested to submit that form and supporting documents through an RFE, request for more evidence. So ultimately, it's going to be up to USCIS how they would like to handle that. If they're going to, as previously announced, that everybody who files for adjustment of status must attach Form I-944 with documents, or perhaps they will just request it through RFE and will be accepting the adjustment packages regardless of Form I-944 being attached. Perhaps they will take the time making the decision, but here is my tip for you. So if you're working on your adjustment of status package, and here comes a day of your filing, and you're not sure what to do, take a screenshot of USCIS website as to what instructions they posted for those who are filing for adjustment of status on that particular date. Okay, it's very important. Especially it's important because on October 2nd, the new filing fees are going to kick in. And as you may recall, filing fees now will be collected separately for Form I-765 and I-131, making adjustment of status package about $1,000 more expensive. So it's important to file your case if you can prior to that date and to make sure that your case is accepted prior to that date. So it's not going to be rejected or kicked back to you for some improvements, all right? But public charge is back, all right? So I don't think it's particularly good news. I don't like it, but that's where we stand right now. Another sort of unfortunately sad news is that the Ninth Circuit on September 14th, I believe it's ruled, it's just today or maybe Friday, very recently, that government administration has authority to cancel TPS status, and court cannot review that decision. It's a very important decision for those who hold TPS or temporary protected status from El Salvador, Haiti, Honduras, Nepal, Nicaragua, and Sudan. Okay? It means that it may be very well that the TPS status will be terminated after the most recent extensions. Hopefully it's not going to happen. We still have at least one lawsuit going on that may change this perspective, but that's the reality. Unfortunately, the court ruled the way it ruled. It means that the decision to terminate TPS or not is within the administration. As you can imagine, the coming up election may probably decide fates of many immigrants in the United States, right? So that's the TPS news. For the rest of the news, what we have is that USCIS, that's a good news, USCIS extended time during which, if you receive request for more evidence, notice of intent to revoke, notice of intent to terminate, and so on, or denial, you get extensions to answer those notices. Typically, you have 30 days to respond. Now, if you receive a request for more evidence during the extended time, and this time is extended up until January 1st, 2021, meaning that if you receive this sort of a notice from the government asking you to act, and it's dated up until January 1st, 2021, you're going to have extra time to act, to answer. And usually it's extra 60 days from your deadline. And for appeals, motions to reopen, it's extra 30 days, because the way the rule is written, it says 60 days from the date of the decision, I believe. So that's very important, because it gives you a little bit more time to act, which is a good thing. And lastly, for immigration courts, for majority of the immigration courts, including courts in New York, all non-detained hearings are going to be postponed through October 2nd. It means, for example, if you have a master hearing on October 1st, it's not going to take place unless, of course, something changes in the meantime. But that's the notice that we received today from Immigration Courts Administration. Okay, so these are the most important news over the weekend and until 7 p.m. about 7 p.m. on Monday today. So hi Shakira, hi Kwasini, Ravi, Vicente, Rochelle, Jacqueline, Renata, Maria, Funella, Karma. Thank you very much, guys, for joining me. Now, if you have some questions, I'll be happy to answer them to the extent I can do it during this format. So, hi Renata, let me see your question. I'm waiting for my final interview for my adjustment of status through American husband. My work travel permit ends in December. When should I apply for extension? I believe you can apply for an extension 180 days before its expiration, if I'm not mistaken. So you can probably file already if it ends in this December, right? Basically file, as soon as you can, and I believe it's 180 days, if I'm not mistaken, before its expiration. So go ahead and file, because it's going to take some time for the government to process. But don't hold me to this time period. I'm going to verify it after this conversation, and I'm going to post it in the comment in reply to your question. Okay. I apply for adjustment of status. How Liridan. I applied for adjustment of status through asylum granted, okay, in 2019, but I have used medicated before I apply, and you use medication, you stole medication. can they deny my adjustment of status for that if I did fingerprints for green card? And then 12, and anything in more frame. If you have something related to some sort of a charges, right? I would advise you not to post any of those questions online or public forums, okay? Because that's sort of a privileged private information that you probably don't want the whole world, including government, to know, right? That you're admitting to something. So I would suggest that you discuss the situation with your lawyer in private, okay? Because as you can imagine, my page is a public page and everyone has access to it. And some situations, that's why we call it attorney-client privilege. When you discuss it with your attorney in private, it's private. But when you discuss it in public forum or during thing like this is not private and I'm not your attorney. So I won't be able to keep a secret. And now the whole world watching us. So I will abstain from commenting on this situation. I would suggest that you consult a lawyer in private, okay? Hi, Quasini. I fill up N400 online. When I check the PDF form in my USCIS account, I found 2 mistakes. So first I see they put that my spouse is a US citizen. Even I put online there, I'm single and I have never been married. The second error I found that this spouse is a US citizen at birth. What do I do to correct these errors? Well, first of all, you can write to USCIS, okay? You also will be able, you will have an opportunity to correct your application at the time of your interview. When you're called for the citizenship interview, this is your chance to make any corrections that of any mistakes you made or somebody made at the time of the interview. Okay, just say that I've never been married, there was a mistake, and if you were never married, so I guess there will be no information about your spouse in your application. So just somehow a wrong box was checked off, either by you or by officer. I'm not sure. I'm staying, generally speaking, I stay away from electronic filings. I like filings on paper. All right. So, but I wouldn't worry too much about that. I think that it is easy to to correct during your interview. So I don't think you should worry about that too much. Hi, Imran. Hi, John. Please, I have a concern regarding my current status. My spouse applied for asylum in 2016 and the case has been pending since then. I'm currently on H-1B and it will max out in January 2020. Although my employer has started green card application and hoping to get the perm approval in the next 2 to 3 weeks or so, and after which they will file I-140 ID adjustment of status sometimes in October, early November, which I think it will be close to when my H-1B will max out. Now I'm thinking of applying for an EAD through my spouse pending asylum case, but my fear is that if it is going to have any negative effect during adjustment of status. Well, I think your employer's lawyer or an attorney who's handling your case probably should tell you about the extension of H-1B status beyond the maximum 6 years when you started the process, when the company, started the process of green card, okay? And those extensions of H-1B can be obtained even before you can file for adjustment of status. So I suggest that you first check with your employer about that, okay? And about adjustment of status situation through employment, if you're planning on filing for adjustment of status through employment, you must maintain non-immigrant lawful status before you can file for your adjustment of status, okay? So I believe that work authorization only will not provide you that status. It will give you a work authorization based on you being dependent of asylum filer, somebody who has the asylum pending status. So usually any employer, or any lawyer, I'm sorry, immigration attorney will tell you that your goal should be, generally speaking, to maintain non-immigrant lawful status in the United States up until the time you can file for adjustment of status if you are filing based on employment. Okay, employment petition. It's very important. So consult with the lawyer who's handling your H-1B case, but that's how it should be. Okay, otherwise, most likely you will not be able to adjust through employment. And of course, there are some exceptions, like 180 days exception, but that's what it is. Usually, a person in H-1B status can file for extensions of H-1B status beyond the maximum if employer started the process of sponsoring them. Okay, so that's, I hope it's going to be a useful piece of information for you. Hi Fabrizio, hi Fionella. How long does it take to receive a notice from USCIS for a date for interview? Forever. Especially right now, it takes a very long time, unfortunately. You know, it depends on what interview, you know, you're looking for, adjustment of status, citizenship, but I would say right now, at least 6 to 8 months, okay? At least, very least. Do you have any news about EOIR? Because I appeal my case from May. Hi, Summit. I think you ask this question every time I'm online. EOIR generally process appeals very slowly, okay? And there is no way for you to basically influence them to process appeals faster. As long as you received a receipt and your appeal was accepted, you have to wait for the decision. I have some cases that are pending in Board of Immigration Appeals now over a year, okay? So it takes time. My friend has asylum case from 2017 February and he doesn't have information. What do you think when he will have information from USCIS? What information doesn't he have? Maybe you're referring to the interview, that he hasn't been called for the interview. Really do not know what's going to happen. You know, some cases are being called already for the interview from 2017. Some are not. I think it depends on many different factors, like quality of the application and also the local asylum office. Oksana, thank you for your hard work. Thank you, Oksana. Very nice to see you here. Thank you. Imran, hi Imran. U.S. citizen, kid is 18 and parent is in removal proceedings with master hearing in November 2020 in Newark, New Jersey. Can the whole process with appeals last 3 years so the kid becomes 21 and sponsors a parent for adjustment of status? You know, it's the court and judges who control the calendar, right? An attorney, generally speaking, do not have power over the court and judges. You can ask for continuance, of course. Recently, such continuances, such requests are being disfavored, and it's hard to receive it. But I think that it's for your lawyer and the government lawyer to discuss if and what relief you may apply for. Now, remember, if you are planning on trying to file for adjustment of status based on immediate relative petition, like through your child, you need to prove that you entered the country legally. It's very important. Otherwise, it will not help you in most situations. Oh, you're welcome, Corsini. Hi, Michael. When should you start renewing your work authorization when you have not been called for an interview yet? As I stated before, actually, someone else asked the same question. 180 days, I believe, before the expiration of your work permit, you can file. All right, so 180 days, if I'm not mistaken, prior. So it's very easy to look it up. I just cannot do it right now. It's form I-765, and instructions to the form will give you definite answer. And the form can be found on USCIS.gov website. Good evening, ma'am. Just a question. Hi, Abu. My wife is pregnant. Congratulations. We don't have anyone here to help. Is it possible to apply for her parent to visit for 6 months? My wife is a green card holder. Oh, I don't think it's possible to apply for the grandparent, right? For her parents to come to help. They can come to visit, but they cannot work. Even if they come, if you say that, listen, they will be coming to work basically as a nanny, that is not possible. But if you're worried, for example, for your wife, if she's well, how the pregnancy is going to go, especially the delivery, of course, it's possible for her parents to try to receive tourist visa and come and visit. Okay, that's absolutely possible. It's a visitor's visa. Currently, depending on the location, it's possible or may not be possible to apply. If your consulate or their consulate is open, you can email a consulate explaining the urgency, why parents should come, and just basically wait for your luck, wait for the answer, all right? But you have to also take into consideration COVID situation. Many consulates are not operating full force, or they have priorities. For example, currently, consulates have priorities for K1 visas, still probably some devolutory cases, so that's something you have to take into consideration. How much do I have to make money-wise to bring my future spouse to the USA? I live in Minnesota. Well, you can check the income requirements by checking form I-864P as Peter at USCIS.gov website. It shows the thresholds for your income based on your household size. Basically, if you have any dependents you're supporting, then your income has to be higher. But if it's only you yourself, right, and you're trying to sponsor only one person, I believe your income should be around $25,000, something like that. But you can verify this number by accessing or Googling even form I-864P, okay? And it will tell you exactly how much money you need to be making. I wish I had memory like that to keep all the numbers in my head, but I don't. Hi, I had my court hearing. The judge said the case will be granted. Congratulations, Wilfred. Then decision date been postponed until now. Any action to take in my case? Well, I'm not sure what kind of relief you were asking. It could have been maybe cancellation of removal. So yes, for cancellation of removal, it's a very common practice that the judge says that he or she intends to grant your case, but you will not get your green card immediately because there is a line of people who are waiting for the same relief. So that's very common. And basically, you just need to talk with your lawyer, if you'd like to, but usually there is nothing else for you to do, just to wait. And the wait time, I believe last time I spoke in court about that, the judge told me it was about 2 years, okay? So it takes some time for those cases, if it's a cancellation removal case. All right, thank you guys. Hi, Justin. Hi, Mr. Vampra. When U.S. Embassy rescheduled biometrics and interview date for CR1. Some embassies are already opened, some consulates. So basically, I would suggest that you write them an email explaining why you would like your spouse to come in. Maybe you're experiencing some hardships, so you should really follow up with the consulate to see if they're open. It depends on the location. I wouldn't know precise information on every location, but I know some of them are opened already. All right. And by the way, I forgot to mention when I was giving you updates that public charge rule, it seems, still to be stopped for the consulates, and healthcare proclamation also is stopped for the consulates. Basically, it cannot be applied. The norms, the regulations, the demands that are voiced in public charge regulations and healthcare proclamation, Trump's healthcare proclamation, do not currently apply for consular proceedings. Of course, for those consulates that are open, for those that are closed, nothing applies. Well, thank you very much, guys, for joining me. Please like, share this video, and I hope to see you soon.